Are you ready for it? I'm ready for it. Well, almost ready. Hold on. Okay. All right. Now I'm ready for it. Now pull up a chair and sit on the floor because we're going to go through your comments and answer your questions. Cheers. Hi, I'm Aiden Durham, business and branding attorney with 180 Law Co. in Colorado. Welcome back to All Up in Your Business. We're going to go through your comments, respond to some comments, answer questions, have fun, drink some wine. It's after hours here at 180 Law Co. So, we're chilling. Rocky is down here waiting for me to take him out on a walk. Maybe Bert will make an appearance. Maybe there'll be surprises. Maybe someone will knock at the door. Who knows? It's bound to be exciting. Before it gets too exciting, the real excitement starts with hitting that subscribe button and hitting that little notification bell so you never miss another episode of All Up in Your Business. All right, let's do this thing. Question: when registering your trademark with your LLC, can you use the name and address of your registered agent? So I think what this question is asking, can you use your registered agent for your LLC's name and address as the applicant or owner on a trademark application? No, that would be incorrect. The registered agent isn't the trademark owner nor the applicant. You might be able to use the address if that's the actual business's address, not just as the registered agent address, but if you're using the registered agent address as the business's principal office address, then that would be okay to use that address. But the applicant owner should never be the registered agent. That should be the company that's owning the trademark. Next, if we can look up our name and logo on the USPTO site, why do we need an attorney? Well, my friend, because it's more than just looking up a name and especially a logo on the USPTO. It's not like Google. You don't just type it in and get a whole plethora of results. It's much more complex. Doing a thorough clearance search can be very complicated. And you have to know exactly what you're looking for. And even if you see all the results, it's a good idea to understand what you're looking at and how to analyze those results and what the USPTO will be looking for in your application versus other registrations. So you don't need an attorney. You can do it by yourself. You can also use my online DIY course, Brandish, if you want to do it by yourself, just with a little bit of help by an attorney. But you don't need one, but that's why an attorney is beneficial, because it's not just a simple search on the USPTO. Is it a bad thing that I created my LLC with my real name, or is it better if I create a fictitious name? I already filed it, seen comments online suggesting otherwise. I can use a DBA. No, that's not a bad thing. There's no, that I'm aware of at least, there's no restrictions in any states of specifically what you can't include in your LLC name. If it is, that it might be against, crude language or offensive language, something like that. But the only requirement in most states with regard to your LLC name is that it include LLC, some designation that it's an LLC. So typically it has to include LLC or limited or something like that, limited liability company, in the name. I mean, potentially there's some restriction or law or regulation or something in your state that I'm not aware of, so it's best to check with an attorney who's licensed in your state. If you're in Colorado, that's perfectly fine. Lots of people do it. Otherwise, check with someone in your state. Aiden, you don't know how much this video is helping me. Oh no, that's nice. I know I'm one of the many you've helped. Thank you for the resource. I'm in the process of starting a, a home bakery. And I have a question when it comes to business entity. Can I include co at the end of my LLC if it's really only a company of one? Does it matter if I have the word company as part of my business name? I see that you have it in yours, 180 Law Co. and make sure, home bakery. Thank you for all your help. You're welcome. So to sum it up, what this question is asking is, can you include co, short for company, in your company name if it's only a company of one? Is I think the gist of that question. And as far as I know, that's perfectly fine to do. You don't have to, you can be a company of one person or a company of many. And like I said in a previous answer, the last answer, The only restriction in most situations is that you have to include LLC. That's the only rule with what you can and can't have in your name. There are some exceptions for certain professions. In the legal profession, there are rules about what we can and can't name our businesses, our law practices. If you're not a lawyer, then those things don't apply to you. It's possible that other professions, like licensed professions, may have similar regulations or requirements or something. But generally speaking, perfectly fine to include co or company or some descriptive designation like that in your business name. Very helpful video. I just became a subscriber. Woo! Cheers. How do you decide if you should change to S Corp status? Is it just if you are making enough money? So great question. Check this video that I did a couple of weeks ago, just posted a few weeks ago. I talk all about S Corps, what it means, when you should and shouldn't do an S Corp election. Short answer is yeah, it's mostly about if you're making enough money. My general rule for what is enough money is if you are generating enough income in your business to sustain and support your business, and that you're able to pay yourself enough that you're living a lifestyle that you're happy with. Basically. So if your business is supporting itself and it's supporting you, then that's at least an indication that you may benefit from the S Corp election. So it doesn't automatically mean you're in a good spot for it, but talk to a CPA or a tax pro, at least if you're in that position. Can single member LLCs get their business expenses deducted? Absolutely. Single member LLCs can deduct business expenses in the exact same way that sole proprietorships can, because single member LLCs are taxed as sole proprietorships. But yeah, anything that is ordinary and necessary, ordinary and reasonable, ordinary and necessary is a deductible business expense. Do you need to apply LLC first before you can apply for EIN? Think. Yeah, I'm gonna say yes. Yes, you should need to, maybe not need, but yes, you should you should form the LLC before you apply for the EIN. It just makes the most sense. And it might be required, but on the EIN application, on the online form, when it asks for the date of formation of the business, it says the date that it was or will be formed. So that makes me think like it's okay to get the EIN prior to when the company is formed. But I don't see any sense in that, I guess. Maybe that applies to if there's some lag time, because I'm in Colorado. So when I file things with the Secretary of State, it's automatic, everything's electronic. So I form the LLC the day that I file the paperwork. Then I can form or apply for the EIN. In some states, there's a lag time because it gets processed. So maybe in that situation, you send in all the paperwork and then you apply for the EIN before the LLC is actually formed. And in that situation, it'd be the same thing. The LLC would be formed as of the date that the Secretary of State's office received it in most states, I believe. So in that case, technically, I guess you can apply for the EIN before the LLC is actually formed. Otherwise, it just makes more sense to get the LLC formed first. What are the costs involved to hire a lawyer to trademark my business? It depends. Of course, every lawyer is different, but I would say to expect to pay anywhere from maybe $1,000 up to $5,000 or more, depending on exactly what you're getting out of the services, exactly what's included, and where you're located, where the lawyer is located. Big cities, lawyers usually charge more versus smaller towns, and how long the lawyer's been in practice. All of these different things are going to play into it, but could be anywhere from, I'd say, around $1,000 to a few thousand plus. But when you're talking to lawyers in general, not specifically with trademarks, including trademarks, but when you're talking to a lawyer in general, trying to figure out who you want to work with, don't just ask about pricing. You want to know exactly what you're getting, especially in a situation like this. For a trademark, a lot of lawyers price things differently and include different things in their packages. tell you mine right now is in the upper 2000s. I'm not going to give a specific number because I might change my price at some point, and so I don't want people relying on this, but it's in the upper 2000s right now for my all-inclusive trademark package that includes every step of the process. What many other attorneys charge more for, they might charge less than what I do, but their packages or their services typically include maybe doing a clearance search, submitting the application, and then responding to non-substantive office actions, like kind of procedural office actions from the USPTO. So they charge a bit less, and they provide just kind of the basics of the trademark registration. My package, it costs more, but it includes everything. It includes responding to those non-substantive office actions and the substantive ones, the big ones, the rejections, the refusals from the USPTO. So you're paying more for me than you might for others, but you're getting more for it. That's why I'm charging more. So ask exactly what you're getting out of the price, and more importantly than the price, make sure you trust the lawyer has good communication, and you think, you feel comfortable working with them, most importantly. Question: when you say start using the trademark, in my case, what if the trademark is a new book series brand? Should I release and publish the book first, or it is simple as starting a website? The two different answers. So it is not, generally speaking, it's not as simple as starting a website. Just starting a website isn't considered use in commerce. You have to be, it depends on what your goods and services are. But no, you have to be selling your products or services. Simplest way I can say it. You have to be actively selling your products or services and using the trademark in connection with that. However, with a book series, I'm glad you said book series, because a trademark for a book title, you can't register a trademark for a book title unless it is a book series. So you have to, I believe, I haven't brushed up on the specific requirements lately, but I believe you have to have published at least 2 books in the series before the trademark can be registered. So it would be use in that case once you've published and started selling the second book in the series. Also, same asker here, footage fetish. I just noticed that. That's funny. Footage fetish. Must be a photographer, maybe a photographer. All right. Okay. Also, I copyright all my work myself. Is it the same type of process? So trademark related to copyright application. Yes, the trademark application and registration process is much more complex than a copyright registration process. Yeah, it's more complex, and it's more expensive as well. The filing fees for copyrights, I think, are between $35 and maybe $65, $75 per application. And with the trademark, it's at least $250 per class of goods and services, and per application. So it's more expensive in terms of filing fees, and the process, everything is generally more complex. And frankly, just because you got the copyright registrations approved doesn't mean they are protecting what you want them to protect if you did them yourself. Same thing goes with a trademark application. Just because you file a trademark application on your own and it gets registered doesn't mean the trademark is doing what you think it's doing. It could have been registered with, there could be errors in your application. The goods and services could be way off, but the USPTO didn't notice. It could be a lot of other issues. So yeah, in either case, it's still better to work with an attorney. My friend is an attorney and he is a PC. He was explaining it all to me, but what is a PC? Great question. I don't talk about these very often. So a PC is a professional corporation. Many states permit you to form a professional corporation or sometimes a professional LLC, maybe other professional types of entities. And these are usually reserved for professions, licensed professionals, usually lawyers, accountants, architects, medical professionals, doctors, that kind of thing. It varies from state to state if they permit it, and then some states or some situations it might be required. The difference between a PC and a corporation or a PLLC and a normal LLC, usually, at least in Colorado, the primary difference, as far as I'm aware, is that the owners have to be licensed in that profession. So if my law firm was formed as a PLLC, then only licensed attorneys could have ownership or membership interest in the LLC versus any other kind of business. A lawyer could invest in it. You could have a dentist as a member, and same thing with other industries. If it's a professional corporation for an attorney, then all the shareholders in the corporation have to be attorneys. As far as I understand, that's what the difference is. If you're not in a licensed profession, then you don't need to worry about the PLLC thing. With using a virtual address for my home business, can I still claim my home business on my taxes? Absolutely, you can. Yep, and really using a virtual home address, that's just another business deduction. It's not actually a office location. You have a legitimate, assuming you have a legitimate home office, you can still take all the regular home business deductions that you normally would. Hey, I currently have a trademark and an LLC. I will be closing the LLC soon. Can I still renew the trademark without the business? Yes and no. You won't be able to renew it. You'll need to assign it to yourself. Well, the LLC will need to assign it to you or whoever is going to be continuing to use the trademark. If you're shutting down the business and you're not going to be using the trademark anymore, then you won't be able to renew it unless you have some kind of excusable non-use. So LLC has to assign it to you or whoever is going to be using the trademark, and then they can renew it. Otherwise, no, you can't really do it. Oh, looks like Little Bird has joined us. Whole gang's here for this party. Oh, look. How'd this one get in there? I didn't mean to. That was a mistake. We don't need to address that one. Okay. Okay. You guys, can we address this once and for all? So many moons ago, I posted a video about trademarks, as I am wont to do. In this video, I made a passing remark about how Google is a strong trademark, which is true. And I said Google is a strong trademark because Google wasn't a word until Google invented it. Since then, I'd say about once a week, I am reminded that that, in fact, is not correct, and Google was indeed a word. Okay, I get it. I'm aware now, you guys, that Google was a word. Google didn't invent it. The point of what I was making in that video remains the same. It's not a very common word, of course. I mean, this person indeed says it's a century-old math term for 10 to the thousandth power. 10 to the thousandth power. I don't know. It's an old-ass math term, and Google misspelled it. My point remains the same of what I was saying there. It's still an arbitrary, strong trademark, or maybe suggestive, but it was not a common term. Not a whole lot of people use it currently, and so I'm aware now. Please stop telling me actually Google was a term. I know. See, you guys, let me hit my phone. Can I hire a lawyer to create and draw up my terms and conditions and privacy policies? If so, what type of lawyer would I seek out? You absolutely can. I would suggest finding a business attorney, someone who works with small businesses should be able to help with those, or contract drafting should be fine. But yes, a lawyer can absolutely do it for you. If a lawyer is outside of your budget, though, you can find some great contract templates for a terms and conditions and a privacy policy and more at the CEO Legal Loft, run by my great friend Michelle Murphy, and I'll include a link to that in the description. You can also sign up for the CEO Legal Loft membership, where you'll get unlimited access to all of the contracts and more. And you'll also get a promo code for 50% off of Brandish, my DIY trademark course. But you have to use my link in the description if you're going to sign up for the membership, if you want that 50% off promo code for Brandish. Can you change or update your single member LLC operating agreement at any time? If so, what's the correct way to do so? So this was in response to my last video where I was answering questions in the comments and stuff about making contributions. And can you make contributions whenever you want? I said it depends on the operating agreement. And can you amend the operating agreement anytime? It's going to depend on the operating agreement. Pro tip here, you guys, for most questions, a large majority of questions having to do with your LLC. Can I do this? Can I do this? The first answer is going to be check your operating agreement. It's going to depend on the operating agreement. That's going to be the first place where we might see if you can and can't do something. Secondary to that is going to be your state statute on LLCs or corporations or whatever kind of business you're operating. If it's an LLC, if you have no idea where to go to look for any of these statutes, best thing I can say is go to Google or your favorite internet search engine and type in your state LLC Act or Limited Liability Company Act. Not every state calls it that. A lot of states title their LLC Act the LLC Act, but that's the group of statutes or laws that will govern the operation and management of your business if it's formed there. So operating agreement first, then state statute. So back to the question, can you amend your operating agreement at any time? Most operating agreements will say this operating agreement can only be amended upon X number of consent or vote, majority vote, unanimous vote of the members. If it's silent on it, then the state statutes might say something similar. Documents, the operating agreement, the LLC agreement can only be amended upon certain types of consent, unanimous, majority, whatever it is. So it depends on the operating agreement. If it's unanimous and you're a single member LLC, then you are the unanimous vote. So yes, as a single member LLC, you can pretty much amend it whenever you want, unless there's some weird restriction in your operating agreement that wouldn't let you do that. All right, folks. Great round this time. Had a lot of fun. Got a little bit of bird action, maybe a little bit of Rocky action, a little bit of wine action. I had a blast. I hope you did too. If you did, if you gained anything from this, be sure to hit that like button and share this with all of your friends. And check out some of my other videos for more hot legal tips and tricks. Thanks for watching. I'm Aiden Durham, and I'll see you next time.